All right, welcome everyone. Thank you for coming for the second seminar in the CIPIL series on intellectual property and information law. And Ruth Okediji started us off a week ago. And now we continue with Kalpana Tyagi, who I know from about 10 or so years back, right, at the Max Planck Institute in Munich, a little bit more perhaps than 10 years. And Kalpana is going to today address a very interesting and timely interface between data, copyright, data protection, protection of personal data, and synthetic data. And how all of that fits together in the context of generative AI. Kalpana otherwise works as an assistant professor at the University of Maastricht, which is a great IP program. So Kalpana, over to you, and thank you for coming.
Thank you so much, and lovely to have you all online and in person. So what I'm going to do in the next 45 minutes or so is I'm going to take you across my research, which is at the intersection of generative AI and intellectual property. I actually started looking at Gen AI as a background from the lens of IP only. But as time passed by, I was very quick to realize that looking at IP doesn't quite give you the entire perspective on generative AI. And I would explain that in a bit why. One such thing, and which also kind of pushed me into data protection, is what we call the rise of synthetic data, so which is kind of artificially generated data. And within the scope of today's presentation, that is what I'm going to talk about. First of all, what is it that we mean by synthetic data? What are the technical aspects thereof? And what are the interfaces of data protection and copyright therein? Because when I talk about data, data can be IP protected, especially copyright. Data is not IP protected, but works from which we derive data is IP protected, to be clear. Yeah. And then if there's an element of personal data, then data protection somewhere peeps into picture. And then obviously we have something called, especially in the EU, which is emerging as a set of what we call data laws, wherein we draw a kind of a binary distinction between personal data and non-personal data. And personal data then falls within the GDPR. So that's already quite a big boundary within the framework of which I would be trying to speak today. Having said that, so first of all, as a starting point, because synthetic data comes as a topic for discussion within the context of generative AI. So I cannot directly jump to synthetic data without talking about what is Gen AI, how does Gen AI function, why is it popular, and why has synthetic data become mainstream? So we all know about ChatGPT, right? It is the fastest growing digital app. Within 3 months of launch, about 100+ million users kind of very quickly adapted and adopted the app. And this is where and when generative AI or Gen AI also became very famous or popular, right? It's not that Gen AI came into picture just 5 years ago, because training and modeling had started decades ago. When did Gen AI become mainstream was when ChatGPT became mainstream, when people started using it in everyday life and everybody started talking about it. And why this is important is because then issues from both the input side and output side, as we'll see in a bit, became relevant, right? And that is why we talk about data. One side, which is IP protected, particularly copyright, which would be the boundary of my discussion, and second hand, the personal data, which is copyright. Now, a working definition of generative AI. I'm sure we all know what Gen AI is, right? When I talk about ChatGPT, for example. These are tools that create content upon prompt. So I give a prompt, I give an instruction, and I get something as an output, right? Now, this output could be anything. It could be written, it could be audiovisual, it could be a programming code even, right? But why is generative AI such an important issue from a legal perspective? Let's first look at a little bit about the background. If I can. So what is generative AI, right? The technical aspects thereof. Now, when I talk about Gen AI, I'm basically talking about something called machine learning, which is a subdomain of artificial intelligence, which is a much bigger field. And what do we do in Gen AI is we basically learn by doing, as human beings do, right? What is machine learning? Machine learning uses tools that automate natural language processing functions, what is called NLP based, right? And now, what was that moment of disruption? That is very important to understand, because NLP has also been there for a very, very long time. The point of disruption comes, which I'll also explain with certain examples, is around 2016 and 17, when Google first started using transformers in NLP related queries. So what is meant by that? So a simulation thereof is a little bit, so before machine learning was a bit mathematical, probability and statistics driven. The point of disruption comes into picture when Google started, not Google, but the scientists at Google, with that I mean, some of them who also got the Nobel Prize this year, they started using a neural network-based approach to machine learning. So before, what used to happen was, for example, if I would try to search apples, right? Google would kind of correlate, it would identify a statistical pattern and see how many people, when they were looking for an apple before, they were looking for apple the computers or apple as a fruit to eat, right? So this is based on statistical patterns or probability driven. When transformers comes into picture, it works a bit like a neural network. So like how our brain functions, we draw correlations and abstract patterns. We try to identify what is the correlation, which is what we also call the dark matter of the brain. And this is exactly what the transformer does in the context of neural networks or Gen AI. Now, transformers became disruptive, and this is where the copyright issue or the IP issue comes into picture, because they kind of transitioned the very functioning of the NLP models. So before, what used to happen was the NLP models were unidirectional. Unidirectional means that they could read either left to the right or they could read from the right to the left, right? And therefore, they could not draw patterns and correlations between different sentences, as an example, right? And therefore, if you look pre-2016, I would not I cannot imagine there was any tool like ChatGPT which could create content or output upon prompt. This starts happening at this point of transformation in time, yeah? And now it can correlate that, it can abstract, it can synthesize, it can manipulate information, right? And this is what happens. And you might have often heard, because you are a technically informed generation, about what we call BET, which is the first neural network-driven Gen AI tool. And its full form is bidirectional encoder representation from transformers. And what happened with BET? BET was a very basic model, but this is a point of disruption and turning point where you really see Gen AI coming into picture. Now, what it could do was, starting BET and state-of-the-art ChatGPT, what we could do was these Gen AI tools could read from the left to the right or right to the left. Now, technically speaking, this is called bidirectionality. So it can be bidirectional. It can read in both the at different levels and in both the directions. Now, this is what gives these Gen AI tools the ability to create content upon prompt. I do a bit of a technical review of the literature, and based on which I draw this, what I call the CII model. So basically, just to give an example, how data which is fed as an input in these Gen AI models kind of transitions and kind of recycles through. And we'll also develop this model further, because this model is up until the point in time when we have generative AI into picture. And when we add an additional step as we go further in the presentation today, what we call synthetic data, this suggests how models like ChatGPT are able to contextualize the information based on the bidirectional approach, how do they repeat this process in a repeated loop, and how they improvise themselves with every step that goes into the picture. Now, this is a bit of an information more about the GenAI models, but what's most important on this slide here is three aspects. The first important aspect is the technical complexity, which I think we are all aware that larger the model and greater the number of parameters, the more complex is the model and the better it becomes. And that's the entire point when I go from GPT-1 to GPT-2, 3, 4, and so on and so forth. But related to that are also two basic limitations which must also be kept in mind, which also become relevant as I start talking about synthetic data. The first aspect is what I called hallucination. We all know and we are well aware that AI hallucinates. It makes up information. Why? Because if you see, when I looked at the CII model on the slide before, when it contextualizes, it understands, and it recreates the process, it does not have a benchmark whereby it can standardize the output that it is generating, right? As an example, if I look at the GAN model, the General Adversarial Network model, or the VAE Variational Autoencoder model, I see it keeps on going on repeated loops without a benchmark. So this is one of the reasons, and this is one of the major problems, which I call confabulation, technically speaking, or AI hallucination. Second limitation, and this becomes even, or perhaps this is an issue in GenAI, I would say, which can be corrected by synthetic data sets. This is, as we know, that there are perceptions and biases in human-generated data, right? That is what GenAI has so far been fed on. And these carry their own biases. We think in a certain way, and then we give this data to the machines, which in turn creates these outputs in the form of GenAI tools, which reflect it's like garbage in, garbage out, or good input in, good input out, that they reflect these biases. This also means that these tools are better in some languages vis-a-vis others for an obvious reason, because there's more information and data available in certain languages, such as English, Chinese, and Spanish. And third important thing, but we won't be talking about it today, is the huge amount of cost which is involved in developing these models, whether it's generative AI or whether it's synthetic data sets. Why? Because you require a lot of technically trained staff, you require a lot of data, and you also require machine learning algorithms to kind of repeat and recreate this process. Now, so far, what we have talked about is that we need data, right? One question that we don't ask ourselves, or at least as yet, is, will we ever run out of data, right? Because human-generated data is limited. There's just as much of data that we have, even if we are producing it in terabytes or so. Now, why this is important is because the entire generative value chain that I'm talking about, it's completely data dependent, and it follows what I call what we call the neural scaling laws. And what is meant by that is that there's a positive relationship between the model and the size of the training data sets. So when we were talking about parameters about 2 minutes ago, we were saying larger the number of parameters, better is the model, right? Where does that come from? That comes from the neural scaling laws. Now, there are two challenges there. Now, on one side, we have certain digital gatekeepers that we are well aware of and which are also being addressed under the DMA, Digital Markets Act. They have access to this bottleneck facility. That's the level one of the problem, right? Why? Because they are the reservoirs or the gatekeepers of the input training data. But at the second level, even they face an additional problem, and that problem is that human-generated data has limited availability. And there are empirical studies that suggest, and that is how this entire discussion and this paper also came into being, that with the current pace, you might have seen the very famous paper by Apple a couple of weeks ago, which was saying that GenAI models have reached their tipping point. One of the reasons that is referred to therein is the amount of data that we have at the moment. The question is, how can we transcend that limit to the availability of data and address the next stage of development in GenAI models. And this is where the issue of synthetic data comes into picture. Why? Because studies suggest that at the current pace of training of generative AI models, we'll run out of the publicly human-generated data somewhere between 2026 and 2032. That means that there has to be another alternative source of data. And that is what we call synthetic data. Now, there are a couple of techniques which are being suggested in order to address this data limitation, like transfer learning, efficient data consumption. I don't go into that, but I focus only on one aspect within the framework of this paper, and that is synthetic data generation. That is, how can synthetic data generation address this issue of the data bottleneck? Now, as we discussed at the start of the presentation, what is a synthetic data set? A synthetic data set is an artificially generated data set, right? It could be anything, which means above, not just what I mean within the meaning of works under Article 2 of the Berne Convention, but also confabulated data or imaginary data, which can be linked to certain individuals. Now, what are the key statistical properties of synthetic data? So why it is important, or why it becomes, for example, when I talk about data protection in a bit, why does it become relevant from the data protection perspective? Now, there are some key features of the synthetic data set. One of the most important attributes therein is that when I talk about synthetic data, it does not identify the data subjects at any point in time, which is very, very important, and which is also the driving difference between what I call the synthetic data sets and the traditional anonymization techniques. Why? Because if the data subjects can be identified at any point in the value chain, it means that that data is not synthetic data, right? And how does it differ from what we call the classic anonymization techniques within the meaning of the GDPR? Now, when I talk about big data, for example, right? Big data has a problem that anything can be de-anonymized within the meaning of big data, which means, in other words, there's not a traditional distinction that I draw between sensitive attributes. Sensitive is like things which I look and I can easily and clearly identify a person. So, for example, somebody in Cambridge, 23 years old, sitting in a room, and it has to be you, you know. For big data, everything is sufficient to de-anonymize it. However, synthetic data goes a step further, and this is what also the studies suggest, that it is a data which is mimicking the statistical properties of the original data. So to visualize how it might look like is, for example, we have a data set about all the people in this room. A synthetic data set would mimic all the statistical properties, for example, all the classrooms that you've been to today, what all you have done during the day, what all lectures did you attend, without actually even distantly identifying any one of in the room here. And that is what is referred to by synthetic data set. And the underlying forces, the moment reverse engineering is possible, it cannot qualify as a synthetic data set. Then obviously there are different techniques of synthetic data generation. Again, I'm not going into that, but what is relevant for us are two aspects from an IP and data protection perspective of the synthetic data generation. The first aspect is where synthetic data is widely used is in the training of Internet of Things, right? For example, when Alexa was yet to be launched, Amazon did not have enough data to know what people might be asking Alexa to do. So what Amazon did was it used the data that it had available on its platform and combined it with, for example, voice patterns, expected customer requests, and so on and so forth, which it called synthetic data. And then it used to train the IoT system. The second aspect is, even when these systems have been trained, they are continuously deployed alongside original human-generated data and the synthetically generated data. And the question then becomes is, in what cases would it be personal and in what cases would that be non-personal aspect of data? Now, we all heard about Geoffrey Hinton winning the Nobel Prize recently, right? Just a small reference there for you to be able to connect to it. The very foundation, one of the foundations which actually led to this entire synthetic data generation was the basic fundamental model which was designed by him, which is called the fully visible belief networks. And what happens in FPBN was, this was the first model that was used to generate synthetic data. The major problem at that point in time was that this was still driven by what you call statistical and probability driven approaches. Now, combine this with the first bit of revolution on generative AI when we talked about, right? It is when synthetic data, as we talked about, combined with the bidirectional approach of the generative AI models, that is when the point in time we get what we call GAN-on-SIG networks or the variational autoencoders, the key generators of synthetic data. Now, throughout the process, with this bit of a technical aspect, we talked about one aspect, right? And that is most relevant to us, and I'm assuming all of us are lawyers in the room, right? And why we have been looking through this life cycle of generative AI, synthetic data, IoT, and what happens when they come together is there's one element which has been common to them out and out. And that element is data, right? Data is the key. Now, we know that data is not copyright protected, which is clear. However, creative form, that is work that consists of data, is copyright protected, right? And within the meaning of Article 2 of the Berne Convention, anything can be a work. It is an open-ended definition. And if I follow the definition of originality, if the definition or the threshold for originality is met, which is that it is author's own intellectual creation, if such a work is used to generate data or create data, that I know is copyright protected. Plus, there's another element which might be personal data. If I look at the entire data that is being used to train these Gen AI models. Now, in order to derive something, to make an output, or even for synthetic data generation, what is it that I'm engaging in? I'm engaging in a process called text and data mining, right? That is the backbone of all these entire processes. The question then is, how am I using text and data mining? And at what stage of the value chain in this text and data mining does infringement from a legal perspective really take place, right? Now, text and data mining is a process wherein you use data to identify certain correlations, patterns, statistical insights, and it is also being used to generate output. Yeah, there are three key steps. There are many steps, but broadly speaking, there are three fundamental steps when I talk about text and data mining. The first step is access to content, right? I need content, I need data. The second step is extraction and copying of this content. And the third step is mining of text and data to derive meaningful information. Now, from a legal perspective, what is most important is step number one, because that is where infringement is taking place, right? If I'm accessing content which is copyright protected, starting with that, if it's even when it's freely available, because freely available, at least in the EU, does not mean that the content is also free to mine. So which means it is this step, the access to content, where infringement really takes place. Now, you all might have heard about these two very famous articles in the EU which talk about text and data mining. First is Article 3 of the 2019 Copyright in the Digital Single Market Directive, which talks about a right for research institutions, universities, and cultural heritage organizations to engage in the conduct in text and data mining. Now, for the private players, on the other hand, and these articles have also been subject to a very nice recent case law from Germany, which I'll talk about in a bit. The question is, what is covered by Article 3 and what is covered by Article 4? Briefly speaking, Article 3 covers research institutions, cultural heritage organizations, and universities, whereas Article 4 covers private enterprises. So if as a private undertaking, you are engaging in text and data mining, the relevant framework for you is Article 4 of the 2019 CDSM. Now, interesting to observe is also the fact that if you look at the articles of the directive, there's a difference in terms of the scope of the rights which are covered within the framework of the two articles. So it might seem at first sight that the only difference between Article 3 and Article 4 is that Article 3 covers research institutions and universities, whereas Article 4 covers private enterprises. However, that is not the case. If I were to look at the scope, for example, Article 3 specifically refers to Article 2 of the Information Society Directive, which talks about the right of reproduction, and also the 1996 Database Directive, which talks about the right of reproduction and the right of extraction. And third aspect which is covered is Article 15 of the 2019 CDSM, which talks about the press publisher's right. Now, this was also a case within the context of TDM before the French Competition Authority, by the way. And then going on to Article 4, it seems to have, in a certain sense, it's a narrow scope, which we'll discuss in a bit because it talks about opt-out. But on the other side, it covers an additional set of rights which are not referred to in the Article 3 of the 2019 CDSM. Now, as of now, we do not know what is the exact breadth and scope of these articles because these are subject to interpretation by the courts or the CJU as the case reaches there. But what is interesting to offer, at least at this point in time, is that above and beyond these three rights, which are referred to in Article 3, namely the right of reproduction and extraction under the Database Directive and the 2001 InfoSoc Directive, and press publishers' right under the 2019 Directive, Article 4 of the 2019 CDSM also offers exemption from the right of reproduction and translation, adaptation, and alteration of a computer program. What is interesting here and why I bring this to your attention is because this right in the EU Acquis Communautaire is anyway subject to Article 5.3 of the Computer Programs Directive. So which means Article 4 offers me an additional right, simply put, to text and data mine within a computer program within the framework of the rights, which anyways are also covered under the Computer Programs Directive. The question then comes is, what is the difference between the scope of these two rights, right? And when we follow the language of the articles, so Article 4(1)(a) and B of the 2009 Computer Programs Directive offers me a right of reproduction, adaptation, and alteration to the computer programs, right? What Article 5.3 of the Computer Programs Directive offers me is a derogation to me as a user with a lawful access to observe, study, or test the functioning of the program, right? So Computer Programs Directive offers me the possibility to observe, study, or test the functioning of the program. However, Article 4 of the 2019 CDSM also offers me a right for text and data mining, so which goes a step further. In that sense, it might seem that Article 4 of the 2019 CDSM clarifies for me a scope of text and data mining of the computer programs within the framework of Computer Programs Directive. Yeah? But, and we all know the big but within the meaning of Article 4, opt-out is a possibility, right? Which means that right holders can opt out and they can tell the firm that please don't text and data mine my data, right? And this is different from Article 3 of the 2019 CDSM, wherein opt-out is not a possibility. Now, the interesting question is, which has recently also been addressed by the German Hamburg Court, is what is the meaning and what is the scope of these articles? As a little bit of a background before, so that we can all appreciate the decision of the court, what had happened was, you might have all heard that in the EU, we had the first decision on text and data mining by a German court. The Hamburg Court recently came out with a decision. And this was in Robert Kneschke versus Leon. And what had happened in this case was the firm Leon, which is Large-Scale Artificial Intelligence Open Network for full form, it's a German not-for-profit firm. It created a Leon 5B training data set. So it used billions of data, which were data points about images, which were available on the internet through Common Crawl. It crawled through them. It filtered these image test pairs, and what it created as an output was only the image descriptions. So, for example, we take a picture of this, yeah, and Leon uses this image to make a description and to hyperlink that this is where the link is available, like on the Cambridge University website, yeah. So it did not download or copy the pictures. All it did was it took the descriptions and the hyperlinks. It did not take the image. So that fundamental difference is very important to see infringement in this case. Robert Kneschke, who was a photographer, one of his photographs was there in these 5.85 billion photographs. He comes up with a claim for copyright infringement. He said, Leon, what it did while it was crawling through the websites, while it was looking at the database of Common Crawl, it was scrapping data from anywhere and everywhere, including from my website, bigstock.com, and it did so without permission. Now, there are certain interesting points that come in the decision and opinion of the court. The first thing as a background was Kneschke says that I had clearly said, so I had given an information about opt-out on my website in a plain, readable language that please do not use my website, do not crawl through it, please do not text and data mine. So he did not give an information in the form of a standardized protocol such as robots.txt, but he said on his website in a simple language. So that was one question before the Hamburg Court. Is that simple language in the form of plain text sufficient to constitute an opt-out within the meaning of Article 4.3 of the 2019 CDSM, right? The second question which was there before the Hamburg Court was, and this is what Kneschke also presented was, now Leon it is a not-for-profit firm, that is what the website says, but the output, this 5.85 billion data set, as we know, has been used by firms like Stability AI to create their own Gen AI tools. So they said, the plaintiff says that even though this is a not-for-profit firm, but the output generated by this firm has been used to mine and train their own Gen AI tools. And these firms that are benefiting from it, some of them are also funding Leon's business model. So they are funding Leon's business model, but Leon continues to be a not-for-profit firm. And the plaintiff's claim or assertion was that in light of this, we should see Leon as a for-profit firm and therefore assess it as a private enterprise engaging in text and data mining under Article 4 of the 2019 Copyright in the Digital Single Market Directive, and not Article 3 of the 2019 CDSM. Why does that make a difference? Because just a minute ago, as we saw on our screens, Article 3 is for research institutions, not for not-for-profit enterprises, for government institutions, for cultural heritage organizations, whereas Article 4 is available for private enterprises. And the court in this case sides with the defendant, Leon. They say that the fact that Leon is being funded by some for-profit enterprise does not make a difference that it remains to be a not-for-profit firm. Why? Because when it releases its data set, that 5.85 billion data set, on the website, this is freely available for anyone in the world to access and develop their own business on generative AI. Second aspect that the court looks at was that what was important, and the court makes this remark in the context of not just Leon, but also Common Crawl, because Leon used the data set from the Common Crawl in turn. It said that these firms, these not-for-profit enterprises, are, as a matter of fact, decoding the black box on which generative AI models are trained. And why the court makes this observation is because we all know that Gen AI gives us some interesting outputs, but at the end of the day, for many of us, if not for most of us, it's a black box, right? And that the court suggests that they are in fact making a positive contribution in the sense they are helping decode the black box of these algorithms. And therefore, the court finally reaches the opinion that the defendant, Leon, is not liable. Why? Because number one, it is not for profit. Number two, the fact that some of the employees are on the board of some for-profit enterprises such as Stability AI does not change the outcome in this case. And number three, the data sets are freely available for one and all. Now, the matter for the moment, at least at the moment, seems to have been settled unless it goes on in appeal. But immediately after the decision was reached, and that was a very interesting, a short but very nice critique by Professor Eleonora Rosati. Those doing copyright may be aware. She immediately came up with a suggestion, and it also rung a bell with me. She said, now, when Leon made the data sets available on the website, this is an act which follows the text and data mining. After the text and data mining has been done, right? The making available of the data sets by Leon should not even be a relevant act under consideration. Why? Because this happens after text and data mining has been done. And therefore, and I'm happy to take questions on that in the discussion, she suggests that as a matter of fact, Article 3 and 4 are not the right framework to assess this case. The relevant framework to assess this case is Article 2 and 3, respectively, under the Information Society Directive, which deal with the right of reproduction and the right of communication and making available to the public. Because if this were the case, then we might reach a different assessment on the facts of the case. And also, as you might be aware from the case law, in Article 3, for example, the court increasingly sees profit motive as a third factor in its assessment on active communication and making available to the public, if I look at the line of decisions like Swenson, GS Media, and so on and so forth. So that's a very interesting opinion, and I think something to reflect on. Now, the court in Robert Kneschke, this case is going to follow us for some time, at least in the EU, also made a very nice remark in the context of opt-outs. Now, I must add that this is an obiter dicta. Why it is an obiter dicta is because if you noticed on the previous slides, I suggested the case was decided under Article 3 of the 2019 directive. Article 4 deals with text and data mining by private enterprises. But the court doesn't go there, but it does make a very, very important, in my opinion, again, very relevant from the lens of generative AI suggestion. It says, let's look at the 2024 EU AI Act. to understand what is meant by opt-out and how should such an opt-out be communicated. Because when I look at the language of Article 53(1)(c) of the 2024 EU AI Act, it uses the word, and it's in single inverted, it says that opt-outs may be exercised in light of the available state-of-the-art technology, right? So in the paper I discuss, so there's much more detail in the paper that is also available on the website now. In the paper, I discuss that at the time when robots.txt came as a standard, right? Because what was robot.txt? It was a little bit like a notice on our entrance door. Please enter, don't enter, enter, knock the door, right? That's what those cookies, they used to tell the cookies, whether you can come and crawl my website or not, right? Now, in current times, when I'm using generative AI, which is based on sentiment analysis and natural language processing tools, I do not need to communicate to another website in a technical language if I don't want them to crawl my website, right? Because if new Gen AI tools driven websites are NLP driven, they can also understand plain text, right? And in this sense, I think the code makes a very nice obiter dicta there. It says Article 53(1)(c) of the EU AI Act suggests that opt-outs could be exercised in light of the available state-of-the-art technology. And the code says that opt-outs can clearly be read by NLP, natural language processing driven tools like ChatGPT, right? And therefore, to give an author rights friendly interpretation within the meaning of Article 17(2) of the Charter of Fundamental Rights, this should be sufficient to communicate an opt-out. Now, that is a question for another day. At what point in time should you look at the state of the technology? And why this is important is because technology is also evolving very fast, right? One of the challenges that we generally face in IPs, we are touching on the moving targets, especially the moment I talk about Gen AI and synthetic data. But having said that, this is a nice obiter dicta to reflect on. Now, with that, let me bring all the complexities together. Yeah. How much time do I have?
Say, and wrap up in 5 minutes, that would be good.
Okay, I'll try. Okay, then, so we already talked about synthetic data, right? We also talked about this value chain, which, so this paper as a background, in case it still interests you, is a follow-on to the first paper, because in the first paper, I talk about copyright, text and data mining, and the innovation dimension of generative AI. In this paper that I'm presenting today, I go a step further. I look at generative AI in the context of synthetic data, and I also add the element of general data protection regulation because GDPR becomes particularly pertinent when I talk about synthetic data. And I'm also equally new to the field because I'm an IP and competition law scholar. But to complete the discussion, I really had to talk about GDPR in this paper. So we talked about contextualization, iteration, and improvisation, right? And we talked about this loop in the context of generative AI. You might see that I have added another layer to this loop. And this loop is, this additional layer is when to complement human-generated data, synthetic data is also added to the value chain, right? So, which means that generative AI models, as we discussed, for example, for IoT systems, for Gen AI models, for their training, you are using sources of data which are not just human-generated, but also synthetically generated to make these models more robust. As an example, to take away biases from data sets. As another good classical example, because I have just 5 minutes, I'll quickly go on to that on data protection bit. What happens is that I need to anonymize data sets as an example. Now, 2 points, and then I wrap up. First of all, you all might have followed that as soon as as soon as generative AI as a starting point came into picture, the Italian Data Protection Authority was one of the first ones to go after ChatGPT, right? And that was a very interesting case. Why? To put it very simply, what they said was that ChatGPT required a legal basis to train their personal data. So in their terms and conditions at the time, it was insufficient to specify what was that legal basis. And ChatGPT very quickly came up with a change in policy. It said that it had a legitimate interest in developing, improving, or promoting its services, including the training of its models. Now, soon after, and thereafter, ChatGPT continued, but one of the criticisms which still comes up in literature is that with this change in policy, what ChatGPT is allowed to do is follow the legitimate interest as regards the personal data of the users who are using ChatGPT, right? But what about non-users, right? There would be many of us who might have still not accessed ChatGPT, right? But we know that ChatGPT has crawled pretty much through all the data that is there on the websites. In this regard, I also, and I would give it a constructive interpretation, a recent opinion by the European Data Protection Supervisor, they basically talk about use of Gen AI tools by government organizations in procurement or something. And it says that Gen AI model providers may rely on legitimate interest, especially with regard to the collection of data as well as for training and validation purposes. So perhaps there's a scope for broader interpretation there, and that is my reflection on this. And one thing on the GDPR bit, which is very important, I'll very quickly just take you through 3 use cases, and I would identify cases wherein synthetic data may help compliance with GDPR and cases wherein synthetic data may fail to meet the requirements of the General Data Protection Regulation. Now, the first question that you have to ask is the data set fully synthetic, or does it comprise of mixed data sets, which means human-generated data or synthetically generated data, or there are elements of both? Now, in the detailed analysis in the paper, I reached the conclusion it is only under situations whereby the data sets are fully synthetic that the requirement for compliance with data protection might be met. All the other use cases would continue to fall within the GDPR when the data is personal, when it involves personal data. And also, again, in the EDPS opinion, one interesting point that came to my attention was it suggests in its discussion that when there has been a use of synthetic data, it is very crucial to ask, number one, what specific controls have been put in place to separate the data sets? And secondly, is it possible to evaluate this data as anonymous through a proven quality? And if so, then it can qualify as pseudonymous or anonymized data under Article 4.5 of the GDPR. And then obviously the partially synthetic data sets or mixed data sets would require compliance with the data protection requirements, for example, under Article 5 of the GDPR, that's lawfulness, fairness, transparency, and so on and so forth. To conclude, I have just 5 points to say. My point number 1 is that I think synthetic data and generative AI have a close interplay. So they do not exist in isolation. To understand and to discuss the debate on synthetic data, you have to start with generative AI as a starting point. And there are different data points, for example, even in the IoT systems, wherein there's a use of synthetic data. There is an innovation dimension to it, which is my point number 2. Why? Because it's not that easy to generate these data sets, right? So even today, research suggests, so there are open access models and you can create synthetic data sets. But if you compare them with the synthetic data sets that have been generated by Gamma, for example, Google and so on and so forth, their quality is far superior. So this is also when you're looking at from an enforcement perspective, whether it's copyright, text and data mining, or data protection regulation, these are factors which need to be taken into account if you have to drive an innovation-driven economy. The third aspect is when I'm now talking about these synthetic data sets, the EU AI Act as a reflection almost looked very heavy to me at the start. But when I started looking at the provisions of Article 53(1)(c) and D, especially when they talk about, for example, you should have detailed information about the data sets. Now, this is a question for another day, whether Gamma would be willing to offer this detailed information. But imagine if this information would be available. It would be very easy for us to identify where in the value chain is there copyright protected information, where in the value chain is personal data and when it gets anonymized or pseudonymized. So I can create the link. I'm not saying we would be able to do it easily, but if the spirit of 53(1)(c) and D is implemented, I think it's a very good provision. The more I look at it, and especially also in light of the Robert Kneschke's decision, it makes a very relevant sense for the Gen AI and synthetic data sets even more. Because why? When synthetically generated data is used, I give examples in the paper to generate more synthetic outputs. You just cannot identify where's copyright. The human author just goes out of the picture. Yeah. And there's a very thin line between hallucination and creativity. So it works very well in copyright. Finally, I think from the Charter of Fundamental Rights perspective, I think transparency, again, coming from the AI Act, this is the flowing from 53(1)(c) and D, and the opt-out and the requirements for data protection compliance under Article 4 and 5. There could be a good balancing of different rights at stake. It's not easy, but it plays out in a very good light when the laws are enforced in a right spirit, to put it simply. And obviously, a good learning during the course of this research was how closely are data protection and copyright related in the context of generative AI and synthetic data. Thank you so much.